Good morning, everybody. I'm Professor Peter Malaguti. I teach here at the Mass School of Law. I teach first-year property and I teach con law. I know virtually nothing about criminal law, so they asked me to start this off. Actually, I'm the faculty advisor of the American Constitution Society, which is sponsoring this event today. Let me put in a plug for the American Constitution Society. You can find it at www.acslaw.org, www.acslaw.org. It's very inexpensive to join, and it is a great educational institution. They do a lot of educational stuff for knowledge of the Constitution. They allow us to put on seminars like this involving constitutional matters. So it's certainly worth checking out. I'm also going to plug the Mass School of Law. If you haven't been here before, I see an awful lot of familiar faces, and it's great to see you guys. I'm a little grayer than last time I saw some of you, and probably a little heavier than last time I saw some of you, but it's great to see you. For those of you who haven't been here yet, I urge you to walk around and take a look at our facility. We have students in here right now in classes, learning. And just a quick note on the courthouse that you walked by on the way in. Does anyone recognize that courthouse? That is the old Chelsea courthouse, the one that used to be above the police station. It was abandoned back about 20 years ago, and our students went down and reclaimed it. And we had a great opportunity to take a real historic courtroom and set it up in this sort of modern building and modern setting. The courtroom is used quite a bit by our mock trial teams and by our moot court teams. So it's a great thing for them. Enough of me. I'm going to introduce the guy whose idea this whole thing is. Actually, Connie Rudnick, but primarily Judge Peter Agnes. So, Judge Agnes.
Thank you, Peter, and good morning, everyone. I'm going to make a few opening remarks, and then we'll have our first distinguished panel, in this case of police chiefs. Over 100 years ago, the United States Supreme Court observed what every lawyer who tries criminal cases in our time soon learns. A deliberate voluntary confession of guilt is among the most effectual proofs in the law and constitutes the strongest evidence against the party making it that can be given of the facts stated in such confession. A confession almost always closes the case and seals the defendant's fate. Today, we gather together with experts in the field of law enforcement, psychology, and criminal trial practice to assess some of the developments in the law applicable to the admissibility of confession evidence over the past century or so. The most remarkable development in the law is that the constitutionalization of criminal procedure, which has led to so many new safeguards to promote greater fairness and accurate fact-finding by juries, has, in the case of confessions, failed to ensure that juries receive reliable evidence. The Miranda doctrine and the related due process test for voluntariness, as they are currently enforced in both federal and state courts, fall short of the protection provided by the common law to a large extent, which they replaced. Because the test at common law, which comes from a United States Supreme Court decision in 1897 in Bram versus the United States, which I won't read in its entirety, but which is printed in the remarks you have, was essentially that any promise, any threat, and any use of what we might today call psychological ploys would render a confession involuntary. This test from Bram versus the United States therefore excludes confession evidence obtained by any sort of false statements or promises and forbids the use of psychological interrogation techniques designed to break down a suspect's resistance to police questioning. But it's been rejected by the United States Supreme Court and state courts, including Massachusetts. What are the results? mounting evidence that despite the constitutional protections afforded by the Miranda doctrine and the due process test for voluntariness, persons in police custody are confessing to crimes that they did not commit and allegedly giving the police details of the crime known only to the police and the guilty party. The courts are admitting these false confessions and evidence, and juries are returning verdicts of guilty. Now, to put this all in perspective, by no means do I mean to say that on any given day in the courts of this Commonwealth or this nation, that confession evidence that's being presented at trial is false. But if you look at the article that's cited in the paper by Professor Brandon Garrett from Virginia, which is printed in the Stanford Law Review, you'll see that he has analyzed the cases involving exonerations of persons wrongfully convicted that were verified by the Innocence Project, and he's examined the cases in which confessions were among the evidence that was offered by the government. And there were over 40 of these. And what he has found in a high percentage of the cases is that the person confessing, according to the reports of the confession, knew details that only the person who committed the crime and the police knew. Well, if the person has been exonerated thereafter, obviously those details seeped into that person's mind somehow during the interrogation process. So if there are problems that aren't addressed by the current law, where did we go wrong? That brings us to the 20th century, the first part of the 20th century, when the Supreme Court was fighting a rearguard action against the use of physically abusive police interrogation techniques by employing the case-by-case due process test for voluntariness, which was really a watered-down version of the Bram test. Miranda versus Arizona in 1966 was a milestone in American constitutional law. It extended the reach of the self-incrimination clause of the Fifth Amendment beyond the courthouse to the back rooms of every police department, and in some cases to the streets and other places where people were subject to custodial interrogation. It established a uniform national rule. If a statement was made during custodial interrogation, it will not be received in evidence unless the defendant knowingly and intelligently waived his constitutional rights before the statement was made. Now, in none of the cases in Miranda would the confession have been excluded under the traditional due process test. Rather, Chief Justice Warren, the author of the opinion, who himself had been a district attorney and was familiar with modern interrogation techniques, understood that the dawn of a new era had arrived, in which psychological approaches to custodial interrogation had replaced the third degree. A person's will to resist police interrogation and exercise the right to remain silent could be overcome without the need to make a threat or to leave any marks. The conceptual breakthrough that Miranda achieved was the declaration by the court that custodial interrogation itself, custodial interrogation alone, is compulsion within the meaning of the self-incrimination privilege. The solution was a set of prophylactic warnings that we all know as the familiar Miranda warnings. Now, we can have a conversation another time about the debate that goes on to this day over whether it was a legitimate constitutional decision, even though the U.S. Supreme Court in the year 2000 said it was. The justices still argue about that. And we don't have time today to survey all the exceptions and all the qualifications to the Miranda doctrine that have developed since 1966. But there is one case that was decided by the Supreme Court last term that I think we will touch on today, and that is the case of Burgess versus Tompkins. This was a 5-4 decision written by Justice Kennedy, which obliterates the distinction between knowledge of one's rights and the decision to waive those rights and speak during a custodial interrogation. The court held that someone who was suspected of a murder and who had remained, for the most part, silent during 2 hours and 45 minutes of interrogation, and then responded yes to a leading question whether he was praying for forgiveness for committing the murder, had not only not asserted the right to remain silent, but actually had waived his Miranda rights. So we must ask, and today's panelists will discuss, whether the court which gave birth to Miranda 46 years ago has dug its grave. But today we face an even greater challenge. We must acknowledge, because the empirical evidence is unquestionable, that the Miranda doctrine, even in its most robust form, is not adequate to safeguard the privilege against self-incrimination. Courts evaluate voluntariness of confessions without independently evaluating whether they're reliable, because the law presumes that a coerced confession is also an unreliable confession. However, in most instances, courts also presume the converse. A voluntary confession is a reliable confession. And in one of the early United States Supreme Court cases, in 1884, they said, if a confession is made freely and voluntarily, it is evidence of the most satisfactory character. It's deserving of the highest credit because it's presumed to flow from the strongest sense of guilt, and therefore it's admitted as proof of the crime. Now, when we discuss what voluntariness is, admittedly, it's difficult to pin down. Justice Frankfurter, in another U.S. Supreme Court case, for that reason called it an amphibian, because it reflects a complex of values. But the traditional test for voluntariness is limited to a consideration of whether the police forced the defendant to confess. It is not designed to identify statements that may, in some sense, be voluntary, but that are simply not reliable. There is an abundance of evidence about which you will hear today that firmly establishes that our courts have failed to fully grasp the potency of psychological interrogation techniques that are in common use today throughout the country, and their pernicious effects, especially on young people and people with mental health problems. And when I say pernicious, I mean they overcome the choice about whether to speak or not to speak, which the Constitution says belongs to the individual. Moreover, modern research establishes not only that these interrogation techniques obliterate the benefit of the Miranda warnings, but they may cause innocent people to confess to crimes that they never committed. So I think today it's fair to say we're at a crossroads. At the federal level, the Miranda doctrine is on life support. I think there's a need for a new approach to combat the adverse effects of contamination, minimization, and deception that are the byproducts of, or the techniques used by police interrogators, at least some, if we are to ensure that the privilege against self-incrimination is not rendered obsolete in the context of custodial interrogations. Now, whether the solution is legislation, new developments in the common law, or constitutional law is something that remains to be seen. Now, we have three outstanding panels this morning to discuss some of these issues. And the first panel is comprised of some distinguished graduates of this law school and lawyers who are also police chiefs as well as criminal law practitioners. I don't know if Professor Rudnick is here yet. I don't think she is, so I am going to pinch hit for her during this first panel and perhaps invite all the panelists to make an opening comment on your experience with the Miranda case and the exceptions and qualifications. Do you think it works well? Do you think there are shortcomings? And if so, what are they? And we'll start with Chief Paul Stewart from the Salem Police Department. Paul Tucker, I'm sorry, excuse me.
Good morning, everybody, and thank you for attending this morning. I come to you this morning with some experience as a law enforcement officer. I've been a police chief for all of 1 year, but I've had 28 years in the police department in Salem, and I'm a proud graduate of the school. Most of my career, I've had the good fortune to spend in the detective division in Salem. Out of almost 30 years in police work, I've spent about 28 years in the detective division. And over the course of time, I've had the good fortune and sometimes the misfortune of seeing people at their best and at their worst. And a lot of what I've done over the years is participated in investigations where Miranda had been a central focus of the case. And as Judge Agnes said, oftentimes the ability to get a confession from somebody is really seen as the linchpin of the case, although we're seeing some different points to that now with some of these so-called false confessions that the next panel will be taking up. When we get into the discussion, I thought I would talk a little bit about some of the police interrogation techniques that some may question and reasonable people can disagree on whether they should be allowed. But I also ask you to keep in mind that while police interrogation and techniques may have improved, so too has the sophistication of the criminals. It may shock some people to hear that criminals actually lie to police sometimes, and we have to figure out where the truth is. So that's some of the things that I'll hope to develop.
Excellent job. Thank you. My name is Lisa Holmes. I'm also a proud graduate of MSL 1999. It was really nice driving down the street again and driving into the parking lot and trying to find a place to park. And I thank whoever put out those signs. I'm glad I came early. I did get one of those choice parking spaces up front, which never happened when you come here. You guys know that, right? I come from a different, unique background. I say unique because I come from a very small police department. For 28 years, I have been on the West Newbury Police Department up on the North Shore near Newburyport and in between Newburyport and Haverhill. And we have 6 full-time police officers, and the majority of our shifts are also filled with reserves. And why I say unique is that we don't have the opportunity, nor obviously the funding, to send officers to specialized training. Our training is comprised of pretty much what we learn at the academy, at in-service, at some classes that we are able to attend on our own, and basically on the job. So we learn from other officers who have come before us, and from there we try and keep up to date with law changes and what's required of us, and try and better ourselves so that we can do the best job that we can. But like I said to some other members on the panel, because of the size of our department and our budget restraints, we do refer a lot of, if we happen to have any serious cases, to state police, and they have been very great at assisting us in providing what needs to be provided, whether it be photographs or fingerprinting or follow-up for some serious case. Fortunately, our community is about 4,700, so it's quite small. We're comprised of a large area that we patrol, but our crime rate is next to nil. So we like to tell the residents it's because of the great job we're doing, but it's really that part of it is. But so my experiences with Miranda may differ a bit with the gentlemen that are from much larger departments. We encounter people who basically tell us, which I can't exactly say what they say, but basically tell us to beat it, that they don't want to talk to us, or they talk to us. So we haven't really had major issues with Miranda. We either get a confession or we don't. And we have to, if we don't, it's disappointing, and we have to find other means of obtaining enough evidence to charge and or arrest that person. So I will be giving a totally different slant on interrogation techniques, training, etc., than the gentleman on either side of me. So thank you all for coming, and I'm pretty psyched to be back here. This used to be my wills and trust class, so so thank you.
I am Ronald Sellon. I work for the Mansfield Police Department. I've been there for 15 years. Our police department is mid-size. We have a community of about 30,000 during the daytime, though, because of our industrial park. It shoots upwards of about 46 to 52,000 people in the community, so it's a pretty good-sized police department. We have the opportunities, because of the size of our department, we have the opportunities and also the negatives that go along with it, in the fact that our first responding officers usually have the opportunity to carry the ball as far as they possibly can with the cases before they hand it off to the detective division. If it's going to be a lengthy operation involving many subpoenas or multiple witnesses or something that may be beyond the scope of something that we can handle over the course of a couple of days, then we usually refer to our detective division, which will then pick up the ball and take it from there. We do have the opportunity to send people to specialized courses depending upon the different type of case that they're involved in, involving interrogation as well as different types of, whether it be homicide or sexual assault cases. So we do have those opportunities because of the size of our department.
Hello, everyone. My name is John Morris. I am a criminal defense lawyer. My office is in Salem. I've done criminal defense probably the past 6-7 years. I've tried well over 50 criminal trials, jury trials, 10 or so of which are life felonies. I've tried all different kinds of cases, a lot of them involving Miranda issues, where my client has been arrested by the police, brought into the police station, and interrogated. And interrogated to the point where it's really doesn't know what he's saying or why he said it. Also under the conditions that he was questioned under. He was lied to. He was deceived into believing certain things. And that's why I'm here today, to give you a different slant, as I think Chief Holmes said, on what Miranda is all about. It's a reality. It's a reality when you defend a person that's charged with a crime. A lot of the police officers will use what they call a threshold inquiry. I believe it's an interrogation. They're in custody. They're not free to leave. But they're using a technique, with respect to the chiefs and the sergeant here, they're using a technique to initiate their investigation through a threshold inquiry. And I think we're going to be able to develop that a little bit as we go through the morning here. So thank you for being here, and hopefully we can answer some questions.
All right.
Chief.
Well, I also like to make sure we take this opportunity to educate Attorney Morris and other attorneys here, too, of the excellent job that police officers do and these nefarious techniques that we use. I thought I'd talk a little bit about some of the things that police officers do, and maybe for purposes of just thinking yourselves if this is something that you feel is acceptable or not. I think the first thing we need to do is distinguish between an interview and an interrogation. They say an interview is a conversation with a purpose. And an interview can take place anywhere. It could be on the street at the scene of an assault, could be at a motor vehicle accident, and it really is something, kind of a fluid situation. The other side of that is the interrogation. The interrogation really is a controlled setting. It's where the interrogator, a police officer, usually a detective, has to stay in control. And it really has to be established right from the beginning. When I was doing interrogations, I would go in a room to make sure there was no distractions, no pictures on the walls, maybe just a couple of chairs, maybe a table. That's it. When the person came in, if he started to take one seat, I'd say, no, sit over here. Right away, you establish control. The other thing that you have to keep in the back of your mind, and I know the court has said, and attorneys will say that a police atmosphere is a coercive atmosphere to begin with. Well, I guess the other side of that is, if we get a couple of lazy boys and a couple of cokes and we all kick back and say, let's talk about this child rape, you're probably never, ever going to get anybody to talk to you. But the fact of the matter is that people want to talk. People communicate. How many people have stepped in a lobby of a big building and hit floor number 28 and they step on with one other stranger? And it's a long ride up. And invariably, you'll say something. If the person has a Red Sox hat on, hey, did you watch the game last night? How about the weather? People feel a compulsion to talk. And I think it's important to get that out, because oftentimes when we bring a confession to court and somebody says, how'd you get them to talk? People want to talk. Now, as I said before, they may not always tell you the truth, but even that's okay, because if somebody lies to you, it still gives you something you can work with. Now, there's three things that I've tried to use over the years that I think work to some extent and are well within good concepts and bounds of the law. And I call it the RPM. It's rationalize, project, and minimize. When you have somebody that comes in that's suspected of committing a crime, nobody's going to come in, sit down, and explain a child rape that they committed. Nobody's going to do that. You've got to talk to them first. And the first thing you've got to do, I call it throw them a lifeline. You've got to give them a reason to talk to you. The first way you can get somebody to talk to you is to rationalize with them a little bit, to get them to understand, hey, it's not so bad. You know what? Other people have done this before. I understand you may have urges or maybe something that made you commit this crime. Make them feel better about themselves. I don't think that's coercion. The second part is projection. Maybe somebody else was at fault. If you've got the so-called weak link out of a two or more person conspiracy, bring that person and say, you know what? I know you're just the fall guy here. Maybe that guy told you what to do. Project onto somebody else. And the third one that seems to work is to minimize. You tell the person, you know what, it could have been worse. That person that you knocked down and you grab their purse, she's going to be okay. You know, she has a broken bone or she got hurt a little bit, but it could have been worse. And in that case, again, I don't think that's coercion. You're really just setting the stage for somebody to be able to talk to you. Now, I'm going to save my other part in a few minutes about trickery and deception. That's why they probably put the biggest distance between myself and Attorney Morris. But I'll save that for the next part.
Chief, let me just ask a question at this point. You just talked about an interrogation techniques that you use regarding the RAM method that you use. Now, is that a technique that you've developed, or is that a technique that you've been taught?
I guess it's a little of both. A lot of police work comes from the police academy, and if anybody that's in law enforcement will tell you, you complete 26 weeks of training, and the first day in the job, an old time will take you out and say, all right, forget everything you learned in the academy, now I'm going to teach you the way to do it. So, but you do have that basic. A lot of it, too, I think, is you've got to have something. You have to bring something to the job yourself. You have to have some people skills. There are probably lots of police officers in the business that maybe are not very good at interrogations because they can't roll with it. I think there's something, I guess it's intrinsic, something that you have to bring to the job, but a good amount of it, too, is training and learning as you go.
Now, your police department is how many officers?
100.
You have 100 officers. How many detectives?
11.
11 detectives. So it's a pretty large police force.
Yes.
They have extensive training, the detectives, in interrogation techniques.
Yes.
They've been sent to classes.
Correct.
I'm cross-examining. Can you
Yeah.
see that?
And I'm agreeing.
Going with the flow.
Yeah. In a minute, I'm going to ask him to repeat the question. We have to break the flow a little bit. So.
The point I'm trying to make is those detectives have been trained in techniques for interrogation.
Yes.
Now, in regards to Chief Holmes' department, a much smaller department, why don't we have her discuss a little bit about the types of interrogations that her department does. Now, we had a little conversation earlier, and she talked about a patrolman would be the initial investigator on a call on whatever the crime is, and that they would pretty much follow through with that. Mm-hmm. So could you just talk maybe about the type of training or experience that those officers have and where they would hand it off to after that?
Okay. As I said earlier, not to belabor it, but my department's extremely small, as is my community. So with 6 patrol officers and myself, oftentimes it could be a reserve officer that takes an initial call for somebody calling, reporting that they just came home from vacation and they found their door had been kicked in and items stolen. That patrol officer is going to do basically what anybody could do, and they're going to respond, take notes, get as much information of when they were gone, where they, et cetera, what was taken. Then from there, we do a canvass of the neighborhood, and from there, usually the sergeant who's in charge of investigations is contacted, and then he will determine whether or not we need to, depending upon the severity of the incident, where we need to go with that. Do we need photographs? Do we need prints? Which, if it was a break, that would be yes. And then from there, what did they notice? Did anybody see anyone? We did happen to have our one and only, knock on wood, house break this year, and somebody actually saw the person fleeing from the house. We did get a good description, however, we were not able to resolve that at this time due to the fact that the party that we believe committed the offense didn't wish to speak with the police. He was in custody and didn't wish to speak with us. So he was one of those people that basically told us to beat it. No fingerprints, no other physical evidence, so no resolution for that offense. But let's turn the flip side of this for what the attorney asked me, and interviewing techniques. That could potentially be the officer that initiated that incident, okay, the one that responded to take the call. But probably it's not going to be that officer. It's probably going to be either one of the sergeants who do have more skills, people skills, I would say. For us, it's not, unfortunately, I'm embarrassed to say this, it's not as sophisticated as, Chief Tucker's department. We pretty much learn on our job, learn from classes that we have attended. And again, not to belabor it, but due to budget restraints, we don't go to the Reed training. which we'd like to, but we just can't. So we pretty much have to go by what we've learned. I have a couple of officers who are very good at conducting interviews. I don't happen to be one of them, never was, which is good because I don't need to be anymore. And you really have to have that knack and that skill to be able to, tell. I mean, you can tell when someone's not telling the truth, but telling and being able to prove are totally different things. And sometimes, we luck out. We have that B&E suspect that we actually, get to come in and speak with us, and the officer's able to obtain a confession from them because here's the facts, here's your fingerprints, here's your picture was picked out of collage of photographs. Help yourself.
Would it be fair to say that the the interrogation techniques that your sergeants, I think you said,
Yep.
would use would be more of a conversational type interrogation as opposed to the techniques that
The
Chief Tucker's detectives?
Yeah, I would say, yeah. Due to the fact that we just pretty much use what we've known and what we've learned from any recent training that anyone has attended, and that's worked for us. I don't know what that says either about us or the clientele that we deal with, but it's worked for us. And the cases that we have been able to resolve have been because someone has either agreed to it or we've had sufficient evidence. So our techniques are basically self-learned in academy and other training learned.
I'm going to talk about the interview rooms in a minute, but Sergeant Sellon, your department I think you described as a medium-sized department.
Yes.
Where you have detectives also?
Yeah, we have our department's about 37 officers total. We have 4 full-time detectives and a detective sergeant. And on shift, the most important thing that I find is that it's a matter of finding the right person for the right job. And just like the chiefs talked about, there are certain officers that are in the area of interrogation and interviewing, to put it kindly and most gently, is they are limited in that area. For instance, I had an officer that, this is some months ago, we get a call, we have a number of house breaks, and we finally get a suspect, and he says, okay, Sarge, this is what I have, this is his name, this is where he is. I go, okay, great, you going to call him up and have him come in? He goes, why? He's just going to deny it. So it's a matter of finding the right person to do that, whereas we have another detective that if we have a child rape case or a murder or any serious case along those lines, if we have to have an interrogation conducted, there's one guy in particular that's one of our detectives that you absolutely positively want him doing that. Because what he'll do is he'll make sure he's just, first of all, he's got a likability factor that the minute that anybody starts to talk to him, they automatically love talking to the guy. And it's just like the chief said, they want to talk. Whether or not, most defense attorneys will tell you, they don't want to talk to you. No, trust me, most people want to talk about it. Whether it's to get it off their chest, whether it's to brag about it, whether it's to throw or cast blame somewhere else, they're going to throw something out there. And the key to it is in separating, for lack of a better way of putting it, the crap from the legitimate facts of the case. And sometimes there are certain people that are very good at that, and other times there are certain people that you want to make sure that, if there's a major case that comes in, that they're not the one that's going to be conducting anything too lengthily.
Now, Chief, Chief Tucker, I want to ask you some questions about the types of the environment that your detectives use to interrogate suspects. Mm-hmm. You said that it's a plain room, plain chair, no distractions, no windows.
Right.
It's a room with a door that shuts.
Sounds pretty coercive.
With a couple of chairs.
Yes.
Steel table.
Yes.
2 police officers.
Usually 1. I prefer 1. Although I've seen, how many people have seen that show, The First 48?
Yeah.
Pretty good show, because they take you right into the interrogation room. A lot of times there's 2 officers in there. I would actually prefer it to be 1. I find 2 is too distracting.
Well, I've had videos with 2 of your officers
Yeah.
in there, but okay. Let's say it's 1. We're in a smaller room,
Right.
That's fair to say,
Yes.
with no way for that suspect to say to the officer, you know what, I'm done talking to you. Because I think what the words you used was compulsion to talk.
Yes.
People do want to tell you and are defensive about what happened. They want to tell you something because they feel they have to. Is that fair to say?
I'd agree with that.
Okay. Now, when they're in this room, the case Holmes versus Giambattista.
Right.
SJC said it's a good practice to record, either audio or video.
Yes.
Are your interviews recorded? And if they are, what's the process that your detectives have been trained to use with a suspect in regards to recording?
Good. That's a good question. The given
I
that
had one.
case, given that the Giambattista case, as Attorney Morris alluded to, the SJC has said it's the best practice that if you're conducting an interrogation, that it be recorded. Now, as I told Judge Agnes this morning before the panel began, I've run into a number of interrogations where the person wanted to talk to me, knowingly and intelligently and voluntarily waived Miranda, but said, I don't want to be recorded. What the SJC case does in that instance is put the ball back in my court and force me to play defense and explain all of this surrounding it. The fact of the matter is that that defendant may 100% have wanted to give me some type of a statement or a confession, but now with that case, and I don't disagree with the case because I do believe it's the best practice, but now they actually put the ball back in the court of the police to have to explain it. That's okay, we can do that. As to the protocols, what we will do is we'll do it in a matter of degrees. The room that we have set up, we have two separate interview rooms, audio and video recording. What we'll do is we have a form. We use the same form. It's a policy that we will go through the checklist with Miranda, and then we'll ask if the person wants to be recorded, audio, video, or both. If the person says they will, we go through it. We set up the tape. We'll do a quick monologue to set the scene for whoever's going to review it after us, and we record it. Best case scenario. Sometimes the person will say, I'm not interested in being recorded. In that case, the default position is, do you mind going on camera to say that you don't want to be recorded? Sometimes they will. The third default is, I'll sign a waiver, I'll check off I don't want to be recorded, and I'll talk to you still. So it's one of those three. Clearly, though, the best practice is for the audio and video, and we do have two separate rooms that we use.
I mean, the obvious is it's best practice for the defense attorney to get the video of the interview at the time, the video.
Yep.
But it also helps us in a way that I don't think the police really think about. We have a client that's denying he said to the police, I never said that, I never admitted to that crime. And if we have the video, we show it to the client. How do they dispute that? And it helps us to defend them, because now they have to be truthful with us. So it works both ways. It's not to challenge the police officer in the way that they did the interrogation, but it helps us with our clients sometimes. So it works both ways. Chief Holmes, your interview rooms. Just room? Okay. Now, is it an old lunchroom or?
No, it's actually a new complex, but no, it's a very small room. We do not videotape. We only audio tape, and it's similar to what he just discussed. There's a round table, a bunch of chairs, and the door shuts. You can leave. I gave him a look. You guys didn't see that. You can leave if you wish. And the chief, I don't want to go over everything he said, but the chief did mention that we do have forms that we all have adhered to from the district attorney's office, and we have to go by that procedure and ask, do you wish to be recorded? And for the most part, most people say yes. They don't really care. So that's great for us. I wanted to ask a question of the counsel, but I'll ask them later about how does he really come up with the answer to if the person said that on camera? Just kidding. That'll be another discussion for another time.
Chief, I haven't crossed you.
Nor will you. So that's our room, and we are in the process of getting. We'll be videotaping also. Videotaping also. It's just a very slow process getting people to work. So as soon as I get that done, you can hammer me on that too.
Sergeant, your rooms, are they videotape, audio tape?
Yeah, our room is very similar to what they call the box on TV, where you have the two-way mirror, and then the other side Ours is there is that two-way mirror window, and then there are two doors in it. One that lends itself right to the detective office, and then another one out. And they both do have windows, so they can see outside. It is audibly and visually recorded, and going back to 2004 when DGM Batista first came out, one of the first issues that police had with the decision when it came out wasn't the fact of that they're attacking our credibility. The first major question that we had with it was the practicality of it. And, well, wait a second, how are we going to record all this? Because in the last 6 years, digital technology really has allowed us to store a lot more as far as that goes, and allows us to record a lot more and keep it on file. But at the time, a lot of departments, I would venture to say, Chief, probably 9 out of 10 departments, if they even had a video recorder, it was an old old VHS recorder, which meant that every single interrogation that you had to do at the time, you had to pop in a VHS, record, and then you had to store that somewhere, and it was just, logistically, it was a nightmare. Fast forward 6 years, and technology has come a long way, so we have a much better opportunity to be able to practically satisfy the requirements of the case. But to answer Counselor's question, it's pretty much, I'd probably say I would describe it as very similar to Chief Tucker's.
I'm going to ask you, Chief, about the Miranda questionnaire or the waiver form that your offices provide. That's provided by the police department,
Yes.
I would guess, right? And it's approved by you?
Yes.
And is there a specific way that your offices are trained to use that waiver, or are they just given it and read off of it?
That's a good question. Again, we don't have a specific policy of how Miranda is actually given. I can tell you the way I used to do it, and I've actually seen in a couple of different cases. I believe in the Berkew's case, I think it was given this way too. What I used to do is, and I'm kind of a cautious guy. I didn't want to lose any cases. So I tried to pay attention to the best practices. So what I would do is, I'll talk briefly about two things. Pre-recording days, if I took a statement from somebody in pursuit of an interrogation, I would actually write that person's statement out, and I would ask them to read it with me afterwards. And I always had them read some of it out loud, because we always had that case where a motion to suppress came up, where they would say the person was not literate and that they didn't know what they were signing. So I would have them read it out loud to me, and I would have them initial and date each page. I've had interrogations where I've asked the person to write out in their own longhand. Sometimes that makes for a little choppier interrogation, and you start to lose that control edge. In terms of reading Miranda, there's the words on the page, and I've got my Miranda card that I have with me. This is 31 years old. This has been read to 1,000 people, and I do it the same way. I ask them to read the first couple of lines just to make sure they can read, and then I'll read the rest of it to them. And if we have the form that I ask them to sign, I'll have them sit right beside me, and we'll go over it line by line. I try to remove any hurdles ahead that I could see that a motion to suppress may look to address. I've probably been to over 100 motions to suppress where somebody said they were so intoxicated, they were so under the influence of alcohol, under the influence of drugs. All of these things that, sure, they waived Miranda, they signed the card, but they really didn't know what they were doing because of all these other collateral issues. And in those cases, I would make notes or make mental notes, how I know the person communicated with me, what some of the ways that they talked to me, some of the things that they said. Again, trying to preempt, looking ahead, what's going to happen in terms of court action. Now, there's also a way to give Miranda and a way to give Miranda. You can stand up there like Joe Friday and stop everything. I get a kick out of, for those of you that might watch Cops on Saturday nights on Fox, you know, the police, they do the same thing all the time. I'm not quite sure. I've never seen it in Massachusetts. But some sheriff from the south will chase a car for 100 miles an hour. The guy will get out. His car will hit a house. The guy will get out and run. They'll chase him for half a mile. They'll ask if he has any bombs, guns, drugs on him. They'll tackle him and immediately whip out Miranda as if that's somehow going to do the right thing, and they're going to interrogate him as they got the guy down on the ground. That just doesn't happen. But the fact of the matter is, you can read Miranda and be very official, sort of Joe Friday from Dragnet, or you can say, look, you have to understand your rights. I'm going to read these to you. If you have any questions, stop me. We'll talk about it. Let's make sure that we both understand what's happening here. Do you mind reading the first line to me? And the person says, you have the right to remain silent. Do you understand that? And as we go through it from there, because I also I value the reputation of myself and my department. I never want to have a reputation that somehow you cut corners or you skirt the facts a little bit. Because if you're in Salem District Court every day, you take a lifetime to build your reputation. One case knocks that down. One time when a judge finds that you've done something that you weren't supposed to, or you cut a corner, or you skirt an issue, or you fudge the facts, that reputation is gone. And in all of my career, and I hope the officers in my department, that when you have to resort to that, then you might as well get out of the business. Because I think that a lot of what we're talking about today, and what the successive panels will be talking about as well, are cases that come to us from the 50s and 60s, where, let's face it, we're not naive. Police abuses, I'm sure, were rampant. I'd like to think today that all law enforcement officers are professional, do it the right way. We know that's not true, and that's why we know that defense attorneys play a vital role in making sure that justice is done. There's things. It's great to win cases when you feel good about it. Question?
Yeah. How about the officers under your control? Are they as aware of your of how to handle Miranda issues as you are? Because you sound like you really handle it beautifully. What about the men and women underneath you?
Chuck, can I address
Sure.
that?
Yeah.
I actually deal a lot with the Salem police. My office is in Salem. I'm in Salem courts all the time. I see the officers that are under his command, and they do a very good job with Miranda. He actually is a very good chief. I don't know Chief Holmes. I don't deal in West Newbury, but Chief Tucker's patrolmen are very good at what they do. They're following exactly what he's telling you. I can tell you that from firsthand knowledge. So
I appreciate that, and that means a lot to me. And to hear that, from the defense attorney, and in a way, it's. I think you're going to find it's kind of a collegial atmosphere in a way, because we may bang heads pretty hard with John during the day, but at the end of it, we all understand we have a job to do. And one thing I never liked, I'm a career law enforcement guy, and one thing I never liked is when, and I hear cops say this too, that defense attorney got this guy off for a technicality. There's really no such thing. That's a defense attorney doing his job. He's zealously advocating well within the bounds of the law, as well we should be too. So that's how we see it.
cops isn't allowed in my house, by the way.
It's not a lot of mine either.
Sergeant, we've been talking a lot about interrogation in a police station, in an interrogation room, in a room with no windows, steel chairs, steel table, with no distractions. But that's not the only time an interrogation occurs, is it?
No.
I mean, we have interrogations out in the field, don't we?
All the time.
Talk about Miranda and the way Miranda is given to a suspect at the scene when the police roll up.
It really depends on what type of a situation that you're dealing with, and I know it's become a tired old cliche in legal circles, but it really does. That's the answer to it. It depends. There have been cases that we've shown up to, and I don't mean to get too graphic, but it looks like a calf was slaughtered in the kitchen, and you've got the suspect sitting on the couch covered in blood, and it doesn't take a rocket scientist to figure out, all right, you know what, before I go talking to this person, I might want to read them their Miranda first, because I got a pretty good idea of what's going on here, versus you show up to a house, the house is trashed, you have two people that are just standing there, and it's an effort to try and figure out what exactly happened. When it becomes apparent that the focus of the investigation is turned on somebody, and that it looks like once you fix it in your mind that you're probably going to end up taking them into custody, or that it's a custodial situation, that's when it becomes very apparent that the officer's got to read the person their Miranda, as opposed to just conducting a threshold inquiry, as John mentioned earlier. In speaking about a threshold inquiry, it's essentially, not to belabor the point, but it's not really a situation that would lend itself to Miranda oftentimes, because sometimes, if you're conducting a threshold inquiry, you don't necessarily mean the person may not be able to go anywhere, but they're also still not in custody as well. And I know that sounds a little hinky to some people, but for the most part it's true, because you may be kicking them loose, you may be keeping them, you may be arresting them, you may be bringing somebody to the scene to witness them firsthand. There's so many intangibles, and it's such a vastly and quickly evolving situation that it's hard to pinpoint exactly if Miranda is necessary at that point.
Chief Holmes, Chief Holmes, let's talk about the I cut him off.
You cut him right off.
I'll come back to him, don't worry.
He's not done with me yet.
I'm not. The best example of a threshold inquiry would be an OUI stop, operating under the influence. Would you agree with that?
Sure.
When you come up, a police officer comes up to the car and asks the operator of the car, based on the way he operated and the police observed him operate his motor vehicle prior to exiting the car, you had anything to drink tonight? That would be a basic threshold inquiry question. Would you agree?
Yeah.
And the courts have found that that's not an interrogation, it's a threshold inquiry. Now, let's change the scenario a little bit. Officers are dispatched to a scene of a domestic where they believe there's a weapon involved, where the alleged victim has been stabbed, let's say. And as they roll up to the scene, they see somebody coming out of the house. Now, they know they're going to a scene that's volatile, where there's been injuries, where there's a weapon. And they see somebody coming out of the house. Talk about threshold inquiry in that scenario.
Okay. I would still use, we're going to stop that person, obviously. We're going to ask questions. You know, what's going on, you know, blah, blah, blah. Make some observations of the person. I mean, if somebody's been stabbed, we're probably going to see blood. We're going to see something. I still don't really consider that rising to the level of, you know, interrogation, and we're going to question them, and they, you know, they have to have Miranda. At that particular time, I'm still going to be just asking them questions, because who knows what they're going to do. They're going to try to leave. They're going to, what are they going to do? You know, there's a multitude of things, and as the sergeant said, you got to play that out as it goes along, okay? I could start out, counsel, just asking some questions.
Who are you?
And all of a sudden, you know, somebody yells out, he stabbed me, or something. Okay, now that's rising to a little bit more serious level, okay?
Well, let me ask you this. As your patrolmen roll up to this house under this scenario, and they see this fellow coming out of the house, they're not going to let him keep on walking, are they?
Exactly, no.
So they're going to detain them, aren't they?
Yeah.
That person. They want to know what their involvement is
Exactly.
in this call.
And where are they heading?
And they're going to ask them, what are you doing here?
Yep.
Where'd you come from?
Who are you?
What's going on in the house?
Yep.
What'd you do? That's not a custodial
I
interrogation?
don't know, maybe not what you do yet.
Okay.
I think,
you
if
know
I
what I
could,
mean?
No, you're not. You're not.
I'll push this one little step further with I believe it's New York v. Qualls. It says that there's a public safety exception.
Right.
And the case was the police officers in New York chased an armed suspect into a supermarket, and they knew he had a gun. And when they caught up to him 2 aisles over, he didn't have it. And they grabbed him and said, "Where's the gun?" And he said, "I threw it under the counter." And his attorney tried to have that suppressed as a custodial interrogation. And the court carved out an exception. Said, what are they going to do? They're going to take their card out. We're going to read this. And in the meantime, some young kid who finds it, you hear boom, 2 aisles over. So there's a public safety exception, too. And I think we could ride that a long way, John.
I think that
I'm sure
I think that the short answer to it is that what is the intent of the questioning? And when you arrive at the scene of what John just described, your first order of business in getting there is to contain the scene. You contain the injuries, you contain the suspect, you contain everything. And in the first order of business is to make sure that everybody is safe, make sure that if there is anybody that's injured that they're obtaining treatment. That is not, the focus of the question is not relating directly to, yeah, exactly. What did you do, or as far as, you know, getting a conviction down the line. Your first order of questioning is relating to, all right, what did you do? What's going on? Well, you know, they could say, well, yeah, I stabbed her. Well, where is she? She's in the basement. Okay, and then that way you can at least address that issue. It's from that point forward now, because it's a constantly evolving situation. And a police officer, when they arrive on a situation like that, their role is consistently shifting between public safety and then prosecutorial. Is that a word?
Yeah.
I think so. In situations like that.
Yeah, I think you can tell. We can tell. We're going to know when it rises up to that level maybe what the sergeant said is, I stabbed her, where is she? She's in the basement. Whoa, okay. To me, that's a hands back, hold off, don't ask him anything further from there, and institute Miranda.
Let me just
from that
change
point
one more
forward.
scenario, and then we'll take questions. Police have a search warrant, Chief Tucker. They suspect that there's drug dealing going on in an apartment in one of your point area housing, which is a known high crime area in the area of Salem. Doesn't matter that
Love that
thousands of
phrase.
people live there every day. There's business there. It's a high crime area. Your officers, detectives, go execute a search warrant, and they go in, and there's an individual in the apartment, and they show the search warrant. They have her sit in the kitchen by herself, and the officers go through the apartment and execute the search warrant. She's not free to leave at that point. Is that fair to say?
Yes.
Okay. And as part of their search, they find a kilo of cocaine in the bottom drawer of a bureau. And they go into the kitchen with the kilo of cocaine and say, "What's this?" Isn't that an interrogation?
That sounds like a threshold inquiry.
Because community caretaking exception?
Just want to know if she knows.
Could be a little show and tell as well.
Yeah.
I actually have a couple of questions I'd like to ask you before we go to questions.
Well, let's finish this.
We have
This is a power struggle going
I
on right now.
I actually, in that case, again, it would be my habit and practice. Upon showing the search warrant, I would also give Miranda at that point. I think it's a safer practice, and that's just something, and I have the detectives do that as well.
Okay.
So,
Go ahead.
and I'm going to ask you, as you sometimes say, you have to answer these yes or no.
I never say that. I never say that.
I just put together a couple of scenarios, and I'm just curious, and John has a lot of experience, and we can kid around a little bit. But in terms of techniques that may be used, I'm just curious if you think that these are coercive or acceptable from a police standpoint. If I had a defendant come in, and I'm interrogating a suspect, and I suggest to him that there may be cameras in the area, and is there any reason, if there is a camera in the area, why he would be on them when he claims not to be there? Now, I didn't say there was cameras. Was that okay?
I don't think it's okay, but the court
Oh,
says
you're not
it's
going to
okay.
like the rest of these then. Now, clearly, if we gave somebody 2 or 3 gallons of water and we kept feeding them the water, they said, I really have to use the men's room. I said, not till you confess. That's way over on the other side, okay? But what if, and this is actually a Boston police case, we have a suspect in a murder, and the detective sets up a scenario where he's talking to this gentleman, and he says, we have the best forensic people in the world that work for Boston PD. We have excellent fingerprint examiners. If you were there, we'll know it. And he drops a piece of paper down in front of him that looks like the outline of a hand on it. Now, what the detective has done is he's gone over to the photocopy machine and taken a photocopy of his own hand. And as he puts it down, now listen carefully what he says, because this makes a difference. He said, is there any reason why your fingerprints would be in that apartment? Now, he didn't say this is your fingerprint. Now, about 30 seconds, things start to churn, and the guy says, I did it, you got me. Is that acceptable?
Well, I actually watched Frontline the other night, and there was a coerced confession story on there about the Norfolk 4. And they kept an individual in the room until he confessed. And the forensics, when that ultimately came out, didn't match him at all. So they went back at this guy, and he gave up another guy. And none of the forensics matched him. And they used the same techniques that you're talking about here. Is it fair to produce what could be considered evidence to a suspect in the conditions that we've described, small room, steel table, steel chairs, no windows, and suggest that that's his DNA to get a confession out of him? Is that fair to that suspect?
Judge Agnes, can you direct the witness to answer the question?
But if it's not his, why would he admit it?
That was, the chief, you're talking about Commonwealth versus Selby.
Yes.
And that in that case, the point was just to give a little bit more credence to the reason why they were able to introduce that is because the suspect all along during the course of that interrogation had been saying, I never entered the apartment. I was out in the hallway the whole time. I never saw anything. I didn't know that there was a body in there, so on and so forth. And when they introduced that, is all of a sudden he started to change his story. And that's when an experienced interrogator really gets a good idea of, okay, I know that I'm onto something here, because now he's shifting his story. Now I know that there's something else to what's going on.
The last one is just is something I've seen done. It's a little bit of a psychological ploy, but it seems to work, and I personally don't find it coercive. You need two co-defendants. You put them in a cell next to each other. You figure out which one is sort of the hardcore criminal and one who might have just been going along for the ride. So you take the hardcore criminal out first, and you walk him by the other cell, and as you do, just kind of put your arm over his shoulder and say, listen, let's go upstairs and talk for a little while. Now, you may go around the corner of the guy saying, you're wasting your time. I'm not going to tell you if your pants are on fire. But you take him upstairs, you have a Coke with him, maybe give him a cigarette, talk to him for about a half hour, and the guy says, I'm not telling you anything. That's fine. No problem with that. We watch a little TV. Well, 40 minutes later, we walk back, and just as we go by the cell, like, listen, I really appreciate that. We had a very nice talk. And we keep going. Now you bring the other guy upstairs. He can't wait to talk to you.
Right.
Okay? Is that okay, John?
No.
Nothing's okay.
In all of these, it really becomes a matter of degrees and that's, again, that's why we have the system that we do. It's the best in the world. It's the engine of cross-examination. It's the good judgment of the district and superior court judges. It's the safety measures in place with the appeals court. That's why we have due process. That's why we have the system that we do. And I like to think that if the police do step out of line, somewhere along the way, it's going to be caught and somebody's going to be made an example of. So,
Any questions? How about this guy in the white T-shirt back here?
yes.
such as that. And I've dealt with a number of cases in which during the interrogation process, the issue of deportation comes up in a certain format of questioning. And that seems to then create an atmosphere immediately of a coercive atmosphere for those now facing not only the pressure of speaking to you, but the threat of deportation. And I'm just curious how it is that your interrogators deal with that situation.
That's an excellent question. I actually see that in two parts. The first is to make sure if we have a non-native English speaker, and in fact in Salem, about 40% of our citizens are of Hispanic origin. In the school department, it's about 50%. So the first thing that we need to get by is to make sure the person understands their rights. And I would not be satisfied if somebody, one of my officers that just knew a little bit of Spanish, trying to get by, I would want to make sure that person knew what was being given to him, what Miranda was, not just the gist of it, but in whole. If we got past that, the second part of your question is a very good one. Is it coercive in nature to simply say, hey, listen, you're under the threat of deportation. You need me to help you. I'll talk to INS for you. I'll talk to these people. I would have a problem with that. And I think that, and we've kicked around a few scenarios here from a moralistic and legal standpoint, I would have a problem with that. If an officer was using that as a wedge to get this guy to talk, there's a great case, the Christian burial speech, where they had a suspect, police officer had a suspect in the back of a police car, and they were trying to find out where this guy had left the body of a young murder victim. And they basically played on his strong religious beliefs, and they honed right in on it. And that really, that was used as a wedge to overcome the fact that he didn't want to talk to them. I think the deportation issue, because it's such a strong issue with some folks, I would have a problem using that. I think that's coercive.
May I ask you more questions? How do you deal with those folks who speak no English? And, we can talk about a billion different types of languages.
Right.
If you have a Vietnamese non-citizen who only
Consulates.
speaks Vietnamese or Portuguese or whatever it might
Yes.
be,
Yeah.
how do you know that you're informing them correctly of the Miranda doctrine? And the reason I ask is that I've had one particular case out of Brookline PD that they had a Portuguese waiver form, and when you had it interpreted into English, it was complete nonsensical.
Yeah. Yeah, there's a couple of different ways to do it. There's resources out there. I would probably reach out, as a sergeant just suggested, we've done it, try to find a representative from the consulate of their country. We also have AT&T has interpreter services that we can use. We also have a very large state university in Salem with a foreign language department. So I try to reach out, but as long as I'm satisfied that it's being done properly, and you suggest in the Brookline case maybe it wasn't been, but I would want to make sure that I'm satisfied that it was done properly. That's a very good question.
Any other questions? Way in the back. You're going to have to speak up. I can barely hear you. It all depends. Do I represent him or don't I represent him? Typically, they'd be coming to me for representation and advice. I can't tell anybody that under the attorney-client privilege.
Let's say there are students and they say, yes, I have these urges, it's not my control. The student's maybe 8 years old, choosing me as a lesson. My job's on the run. Would you become that person?
I absolutely will. There's a couple of people in here that know me and the types of cases that I take. I'm actually on the SDP panel. I defend sexually dangerous persons from civil commitment for life. So I take just about any case that comes down the road. It's not about defending what they did or didn't do. It's about defending their right to freedom. Their liberty's taken. My job is to make sure that the police do their job correctly. My job is to make sure that the prosecutors do their jobs correctly. So it's not about what the crime is. I mean, I could really make a lot of people squirm in their seats right now about the types of cases I have. So that doesn't have anything to do with it for me. I don't understand the question. None. I have none. Absolutely none. My job is to make sure that Chief Tucker's detectives did their job correctly, to make sure that he was Mirandized before he spoke to the police, to make sure that all his rights are preserved. I actually got a call from a client the other day, about 4 o'clock in the afternoon. He was just taken into arrest by the Linfield Police Department. I called the Linfield Police Department to talk to the arresting officer who got on the phone. And I told him that I represented this person and that I did not want him interrogated. I did not want him questioned. He's invoking his right to remain silent under Miranda. And I got nothing but attitude from that police officer. What don't you understand about that? I mean, I think that's pretty clear. Yes. Any other questions? Go ahead.
I do have one question about the whole control situation. Have you ever had a situation where you walk into this rather spartan room and you're telling the person to take a particular seat where you want to sit, but he's sophisticated enough to be playing the same game with you, he won't sit there. Or if you have the two-way glass, obviously you want him on the opposite side. He knows that, and he wants to sit with his back to the glass. Number one, and number two, if you've had that situation, how do you handle that?
I can't say offhand that I have. Certainly, we've run into a lot of resistance in interrogations. I can't specifically think of a time when somebody's been that adamant or defiant. I've had suspects that didn't want to sit down, but eventually they do. I've had suspects that didn't talk, so I'll sit there. Eventually, if you sit in the same room with somebody for a long time, I've gone and sat down, and the person didn't want to talk, and we'll just sit there together for a while. After about 15 to 20 minutes, which seems like about 3 or 4 hours, they'll say, "What? What? You know, aren't you going to ask me anything?" Now you've broken the ice, and a lot of it again is trying to think ahead. It's great to go into an interrogation with a game plan, and part of the game plan is you've got to know the crime inside and out. You hope to know something about the background of the person you're interrogating. You try to figure out exactly what happened. Maybe you don't know exactly. But a lot of it is moving on the fly. And I think a lot of it is what defense attorneys do in cross-examination. You could have a whole game plan, but if you get an answer that's a little different than you expected, you might have to go off in a whole different direction.